Welcome to the 2013-2014 Law Enforcement Legal Update. This portion, we're going to review the Supreme Court cases that came out from the 2012-2013 session. Now, the last term was very interesting. It ended with major rulings on civil rights issues. These issues included affirmative action, voting rights, and gay rights. In fact, if you watched the news and paid attention at all, you saw some of the big questions that came out of this term. How much can a college consider race in deciding which students they'll admit? Can the federal government deny health benefits to married gay couples? Can the federal government continue to require that states with a history of discrimination against black voters get prior approval before changing their voting laws? These were the topics that took up a majority of the Supreme Court this term. All right, so the first case that we're going to look at is Bailey versus the United States. In Bailey versus United States, this is an appeal from the Second Circuit Court of Appeals in which they ruled that officers may detain departed occupants of a premise about to be searched as reasonably practicable. This rule allowed the detention of two individuals observed leaving the premise almost a mile away. The Supreme Court rejected this ruling, finding occupants may only be detained in the immediate vicinity of the premise. This does not, however, mean that such persons may not be detained if officers have reasonable suspicion they are involved in unlawful behavior under Terry. So, let's talk about the facts of this case. Prior to the execution of a search warrant for a handgun, officers on scene, or the surveillance officers, observed two men leaving the gated area above an basement apartment at 103 Lake Drive. Now, that was the target of the search. That was the location in which the search warrant was going to be executed. Both men fit the descriptions of the suspects as testified by the officers. The suspects were tailed for about 5 minutes for a distance of about a mile before being pulled over. After they were pulled over, a pat-down revealed only a set of keys, which included a key that was later found to fit the door of the subject premises. That's the 103 Lake Drive premises. Bailey, when interviewed, says that he was coming from 103 Lake Drive, but his license showed that his address was Bayshore. And that's important because an informant had told police that one of the suspects, whose nickname was Polo, used to live in Bayshore. Both men were handcuffed and transported by a marked cruiser back to 103 Lake Drive. Now, in conducting the analysis of this case, the Supreme Court reviewed its prior decision in a very important case called Michigan versus Summers, which was a 1981 decision. The Michigan versus Summers ruling stated that officers were allowed to detain occupants of a premise covered by a search warrant without individualized suspicion of unlawful behavior. In fact, there have been a handful of cases that I recall over the past 10 years which discussed whether or not you could detain an individual, handcuff an individual, or keep the individual on scene during the course of a search warrant execution. The court in this case articulated three very important law enforcement interests that justify the detention. They are described as minimizing the harm to officer, orderly facilitation of a search, and preventing a flight. Now, we're going to break these down one by one. Okay, first, minimizing harm to officers, the argument that was utilized for detaining the individuals that had walked away from the scene. The execution of a warrant to search for narcotics is the kind of transaction that might give rise to a sudden violent or frantic effort to conceal or destroy evidence, and the risk of harm to both police and the occupants is minimized if the officers routinely exercised unquestioned command of the situation. That's the summary produced by the court. However, the court found this interest did not apply to departing occupants. First, police need not stop those departing, and second, if they believe such persons are dangerous or involved in criminal activity, such persons may be stopped under Terry. The court also rejected the argument that those departing might notify others in the meeting of the impending search. It reasoned that this justification might apply to anyone in the neighborhood who might alert remaining occupants. The second area that was utilized as the basis of conducting the detention was an orderly facilitation of the search. That is, as the court identified, allowing occupants to wander around, potentially interfering with the search, destroy evidence, or distract officers allows for the detention of occupants. But these interests also did not apply to those who had departed the scene. Occupants may also assist in search by opening locked doors or containers, or in other ways help to avoid unnecessary destruction of property or delay in the execution of the search. In this case, Bailey informed officers he would not cooperate. Therefore, facilitation did not justify detention of occupants a distance away from the premises. The next argument used was preventing flight, and the court looks at its prior decisions in the Summers case and states, well, the Summers court found a legitimate law enforcement interest in preventing flight in the event that incriminating evidence is found. The Bailey court explained that this interest did not independently justify detention of an occupant beyond the immediate vicinity of the premise to be searched. The decision to effect a detention under Summers must be acted upon at the scene of the search and not at a later time in a more remote place. If officers deferred detention until the suspect or occupant has departed the immediate vicinity of the premises, the lawfulness of any detention is governed by some other rationale, such as a reasonable suspicion under the Terry/investigative detention doctrine, or an arrest based on probable cause. We're discussing this term immediate vicinity. And what we looked at is the court identified once an occupant is beyond the immediate vicinity of the premises to be searched, the search-related law enforcement interests are diminished and the intrusiveness of the detention is more severe. The court recommended factors that the officer may consider in seeking to determine the limits of the immediate vicinity include the lawful limits of the premises, whether the occupant was within the line of sight of his dwelling, the ease of re-entry from the occupant's location, and other relevant facts. The best course of action would be to stop departing occupants only with reasonable suspicion. If reasonable suspicion exists, officers should use as little force as necessary and detain them at the location of the stop until receiving information from those conducting the search. All right, let's transition to one of our next two cases, and there's a total of 6 cases in the Supreme Court review. The next 2 cases are both canine cases, and they both come from the wonderful state of Florida. So we're going to talk, the first one is Florida versus Harris. In this case, this is about drug detecting police dogs. In this case, the court has held that an alert by a reliable drug detection police dog provides probable cause to search for contraband. In this case, the dog alerted to the door handle of a stopped motor vehicle. But the facts of this case are one that actually we're going to have to look at so that you understand the reasoning of the court. The court rejected the approach taken by the Florida Supreme Court. That's why we have an appeal. That approach was, it required strict satisfactory adherence at a suppression hearing to an evidentiary checklist before the dog can be deemed reliable. So as you see in this case, the question is when is the dog reliable and what evidence is needed to support the reliability of the canine? The court has said that probable cause of a canine's reliability depends on a totality of the circumstances equal to any other probable cause determination. The facts of this case, Officer Wheatley walked his canine Aldo around Harris's truck after Harris refused to submit to a search. The dog, Aldo, alerted to the driver's door handle. The search of the vehicle, and obviously that alert then led to a probable cause standard, which allows the vehicle to be searched. The search did not turn up any drugs, but did reveal ingredients for making methamphetamine. A few weeks later, while out on bail, Wheatley stopped Harris for a broken taillight, and Aldo again alerted to the driver's handle. This time, the search again revealed nothing. At a suppression hearing Wheatley testified to both his and Aldo's extensive training, and the state submitted monthly canine detection logs which showed that Aldo always found hidden drugs and that he performed satisfactorily. Harris's attorney challenged Aldo's field performance, especially the 2 negative hits on Harris's truck and the lapse of his certification. Wheatley admitted to not keeping records of all Aldo's traffic stops or field work and noted that the state law in Florida did not require him to do so. Evidence of the dog's satisfactory performance in a training or certification program can itself serve as satisfactory evidence of its reliability. At any hearing, a defendant, of course, must have the opportunity to challenge the dog's reliability, either through cross-examination of the handler or the presentation of his own evidence, including expert testimony. In Harris, the record supported the trial court's determination that the dog's alert did give rise to probable cause. Now, specifically as it applies to canine officers, well, you should ensure that you're keeping good records. You have a specialty, you have a special tool at your access, and therefore, when it comes down to the training and experience of the dog, you're going to have to articulate that in facts and circumstances, records, training, and ensure, like they did in this case, make sure that your certification stays up to speed. I think this also has an important part, and it goes to all law enforcement. There's a lot of individuals in law enforcement that have specialty certifications, and it is your duty to ensure that you protect your certification, because if you have to go to court and you have to go there for the purposes of expert testimony based on your experience, the first thing that's going to occur is you're going to have to lay your experience out, and that experience is also certification, experience, and history is going to be open to scrutiny and cross-examination by opposing counsel. The next case before us is Florida versus Jardines. Again, another Florida case, again, another dog case. In this case, the court has held that police conducted a Fourth Amendment search of a protected curtilage when they entered upon the front porch of a private residence for the sole purpose of searching it with a drug-sniffing dog. The search was found unlawful because it was done without a warrant, no exception to the warrant requirement was asserted, and the conduct exceeded the scope of any implied license that the homeowner may have conveyed in a general sense to anyone. The facts of this case. Miami-Dade police, they received an unverified tip that marijuana was being grown in the home of Jardines. About a month later, detectives from Miami-Dade police, accompanied by a DEA agent, surveilled Jardines' house for about 15 minutes. They saw no vehicles in the driveway, no activity around the house, and they could not see inside as the blinds were drawn. One of the detectives, along with his drug-sniffing trained canine, approached the front door from a walkway leading from the driveway. The canine, whose name is Frankie, was on a 6-foot leash. He sat at the base of the front door, indicating the location of the strongest smell. The officers immediately left after being on the property for about 2 minutes or less. Based on the information obtained from the hit by the canine Frankie, detectives obtained a warrant, which was executed the next day, leading to the discovery of marijuana plants and the arrest of Jardines. The United States Supreme Court in California versus Sorello in 1986 clarified curtilage. He defined it as the area immediately surrounding the home. They stated it's immediately linked to the home, both physically and psychologically, and is where privacy expectations are most heightened. In this case, they stated officers were not licensed to enter Jardines' property in the context of this case. They clarified, while any person, including police, would be licensed to walk up to a front door and knock and even talk to the occupants, they were not licensed to enter the property with a trained drug dog to explore for incriminating evidence. Barring measures taken by the homeowner, which make it clear that no one is impliedly invited to approach the house or ring the bell, that is, a big sign that says no loitering, no solicitation, don't enter. The police may enter upon curtilage for this purpose, and they are, of course, free to receive and utilize their sensory information as they do so. And we'll talk about that. This is not what happened here in this case, the court identifies. The Supreme Court said the police entered the curtilage for the sole purpose of deploying the dog, and no one is impliedly invited to enter the protected premises of a home in order to do nothing but conduct a search. There's 4 areas that were broken down in this case, and the first is whether or not this was a restriction on the use of canines, and was it a restriction based on their general use of dogs? In interpretation, the court says, no, I don't think it limits the ability to use dogs in searching premises, but however, there has to be a basis to do so. The second is the presence of canines for other intended purpose is still lawful. What does that mean? Well, listen, if you're utilizing a canine for a track or missing person search or one other of its tools, and in the course of doing that, it gets a hit on drugs, then the reason it was there was still a lawful reason. Plain smell by an officer is still lawful. That is, hey, you still get to use your 5 senses. You can hear, you can see, you can touch, you can feel, you can taste, and if you can utilize those senses to obtain information that leads to probable cause, then you're still allowed to do so. All right, let's summarize this case. Specifically, the officer in this case entered the curtilage of Mr. Jardine's house with a drug-sniffing dog, specifically for the purpose to attempt to obtain evidence to support probable cause for the search warrant. And the court said, not going to work. That's not the way that this is going to be allowed. It was a Fourth Amendment violation because that tool, the dog, was brought into the curtilage specifically for the purpose of smelling for narcotics. We have to take what we can with this case, and that is ensure that we provide sufficient protection for the curtilage of a residence, ensure that we keep in mind and ask ourselves the question, what is the expectation of privacy when we enter the curtilage? The good part of this case is the court made it clear again. You are open, you as an officer, as is society. I can approach the house, knock on the door, and have a conversation with the owner of that lives there without any Fourth Amendment curtilage violation. The next Supreme Court case up is Missouri versus McNeely. This has to do with the taking of blood on a DUI stop. In this case, the United States Supreme Court has held that the natural metabolic dissipation of alcohol in the bloodstream does not present a per se exigent circumstances justifying the warrantless and non-consensual blood testing in every DUI case. As with other applications of the exigent circumstances doctrine, its application in the context of DUI investigations is assessed on the fact-specific, case-by-case basis. The facts in this case support that about 2:08 a.m. on October 3, 2010, a Missouri trooper stopped McNeely after observing him exceeding the posted speed limit and crossing the center line 3 times. The trooper observed that McNeely had bloodshot eyes, slurred speech, and a strong odor of alcohol on his breath. McNeely, when questioned, admitted to having a, quote, couple beers, end quote, at a bar. During the field sobriety test, McNeely was unsteady on his feet and performed overall poorly. He declined to submit to a preliminary breath test, and as a result, he was arrested for driving under the influence. While en route to the jail, McNeely stated he would not voluntarily provide a breath sample. As a result, he was taken to a nearby hospital to obtain a blood sample to secure the evidence of intoxication. At the hospital, the trooper directed the lab tech to draw a blood sample without a search warrant. So there was no search warrant at the time, which is the issue in this case. The trooper stated that it takes more than 2 hours to get a search warrant, and one was not requested. This approach makes critical the development of a proper factual record showing the impracticality of timely securing a warrant in each particular case. Because McNeely was presented and argued on the basis of a per se exigency in DUI cases, the court was not called upon to offer a detailed discussion of all the relevant facts that may be taken into account in determining the reasonableness of acting without a warrant. It did, however, note the following relevant factors. The first relevant factor was the rate of metabolization of alcohol in the bloodstream, which of course results in a loss of evidence over time. Number two, the difficulties presented by the passage of time in being able to accurately backwards extrapolate a BAC. And number three, the practical problems of obtaining a search warrant within a time frame that still preserves the opportunity to obtain reliable evidence. Regarding the third factor, the time it typically takes in a particular jurisdiction to secure a search warrant is pertinent. As in the facts here in Connecticut, unlike a majority of the states and federal government, does not provide a procedure by which the police may remotely submit and obtain a search warrant by telephone or other electronic means. This, of course, is pertinent with respect to the time it takes to submit and secure a warrant here. In order to help state's attorneys, district attorneys, or whoever your prosecuting authority is, we need to make an accurate record to defend the evidence that's obtained. Officers need to ensure that they understand that warrantless and non-consensual blood testing is not automatic in a DUI investigation, and that they must make an individual assessment in each investigation regarding the existence of a true exigency. What should the police agencies do? Well, my recommendation is refusal to voluntarily submit. If time permits, a warrant should be obtained. Number two, if not reasonably based on time, you got to explain. You got to clarify why time is of the essence. Now, in a lot of states, this case has actually morphed into allowing an opportunity or presenting a manner in which officers can telephonically call in a search warrant for DUI evidence. In other states, this case has actually morphed into the ability for officers to call into prosecuting authorities or the courts telephonically to get a search warrant. However, not all jurisdictions have that at this time. All right, the next case up is Maryland versus King. And Maryland versus King has to do with obtaining a DNA sample upon an arrest. The United States Supreme Court has held that the practice of subjecting a person validly arrested upon probable cause for a serious offense to the minor intrusion of a brief buccal swabbing of his or her inner cheek to obtain a DNA sample for identification purposes is a reasonable search under the Fourth Amendment that can be considered part of a routine booking procedure. In 2009, Alonzo King was arrested for assault in the first and second degree. Pursuant to the current statute in Maryland, officers took a buccal swab from inside his cheek. The DNA that resulted from that swab matched evidence from a rape kit that was committed from a rape case that was committed in 2003. The issue before the Supreme Court was whether the Fourth Amendment prohibits the collection and analysis of a DNA sample from persons arrested but not yet convicted on felony charges. In a 5-4 decision, the Supreme Court weighed the level of intrusion against the government interest and held that such a search is permissible. The court noted that DNA technology is one of the most significant scientific advancements of our era, with unparalleled ability to exonerate the wrongly convicted and to identify the guilty. Currently, all 50 states require a collection of DNA from felony convicts. 28 states and the federal government have laws similar to Maryland's authorizing the collection of DNA from some or all arrestees. The King decision does not uphold the taking of blood as part of a reasonable booking procedure. Important to the analysis in King is the negligible and minimal intrusion nature of obtaining a buccal swab sample, a practice it expressly distinguished from the drawing of blood. In Connecticut, when implementing the Connecticut General Statutes 54-102Ga, do so with a buccal swab and not a blood draw. A quick review of Connecticut law from my Connecticut officers is that pursuant to 54-102G subsection A, and all of you might, in different parts of the country, might have a statute out there that has the same tone, states whenever any person is arrested on or after October 1st, 2011 for the commission of a serious felony and prior to such arrest has been convicted of a felony but has not submitted to the taking of a blood or other biological sample for DNA, analysis pursuant to this section, the law enforcement agency that arrested such person shall, as available resources allow, require such person to submit to the taking of a blood or other biological sample for DNA to determine identification characteristics specific to the person. Okay, and the sixth and final Supreme Court case for review today is Salinas versus Texas. This basically was described, and as you look at the publication document that's on the publication section of Daigle Law Group, you'll see I titled the document in analyzing this case, Suspects Must Speak to Invoke a Fifth Amendment Protection. The court has held that a suspect who submits to a voluntary, non-custodial interview with the police must expressly invoke the Fifth Amendment privilege against compelled self-incrimination in order to subsequently benefit from it. Such person does not invoke the privilege by remaining silent, even in the face of official suspicions. The facts of this case show that in December of 1992, two brothers were killed by a shotgun in their Houston home. An investigation into their death led police officers to the home of Salinas, who had been a guest at the party the victims had hosted on the previous night. The police had recovered 6 fired shotgun shells at the scene of the shooting. When the officers visited Salinas at his home, he agreed to hand over a shotgun for ballistic testing and voluntarily accompanied the officers to the station to answer questions. He was not in custody and Miranda warnings were not given. When asked whether the ballistic crime scene evidence would match the shotgun he had voluntarily given the police for testing, the petitioner balked. He said nothing. He looked down at the floor. He bit his bottom lip. He clenched his hands in his laps and began to stiffen. After a few moments of silence, the police asked several other questions, which the petitioner answered. At the end of the interview, Salinas was arrested on a traffic warrant and he was subsequently released. The prosecutor decided to charge, but Salinas disappeared, and he wasn't found again until 2007. Salinas did not testify at trial. Despite his objection, prosecutors used his reaction to the police questioning during the 1993 interview as evidence of his guilt. As a result, the jury returned a guilty verdict, and Salinas received a 20-year sentence. Salinas appealed to the Texas Court of Appeals, arguing that the prosecutor's use of his silence during the interview as part of their case-in-chief violated his Fifth Amendment right against self-incrimination. The Court of Appeals summarily rejected this argument. The court confirmed that a witness who desires the protections of the privilege against self-incrimination must claim it at the time he relies on it. In upholding the use of the evidence at trial, the court discussed the general rule requiring expressed assertion of the Fifth Amendment and the 2 exceptions thereto. The 2 exceptions are, 1, a criminal defendant need not take the witness stand and invoke the privilege at his own trial, and 2, that a person need not expressly invoke the privilege where some form of official compulsion denies him a free choice to admit, deny, or refuse to answer, such as the inherent compelling pressures of an unwarranted custodial interrogation. The court stated that neither exception applied here, and as a result, Mr. Salinas' refusal to speak was used against him. That wraps up the Supreme Court portion of this training. We hope you enjoyed it. As always, keep up to date with the Supreme Court decisions as they're released by making sure that you're logged in and registered for the Daigle Law Group newsletter. If you're not, register on the website www.daiglelawgroup.com. Thank you.